a couple of quick announcements before I hand this mic over to Beth. The workbook that Noreen mentioned last week, or last month rather, came in, Death Doula's Guide to Living Fully and Dying Prepared, and they are available if anybody's interested in purchasing one. And I just found out that Noreen would like to know if anyone thinks they might be interested in participating in a workshop with this.
I put my name on.
Okay, good. Small group, and actually, I guess, working through the actual guide. So if you think you might be interested, put your name on the list, which I think is, going to be back with the books. All right. And we do have a speaker for November. His name is Dr. Kenneth Donovan. He's Director of Palliative Care at L&M, Lawrence and Memorial Hospital. So if you come to that, that would be good. And our speaker this evening is Beth Leamon, who most of you probably already know of, and she's a member of our group. Beth grew up in Mystic, attended Stonington Public Schools, graduated from Stonington High School in 1985. She's currently the probate judge for our district. Beth has practiced law for 20 plus years, and her focus is on trusts, estate planning, and estate settlement. So I can say we're grateful to have her as a member of our group and appreciate her giving her time to speak with us this evening.
Thank you. Voila. I'll put this on my lapel. Okay. All right. Well, thank you for the introduction, Lavina. Okay. I was asked to talk today a little bit about advance directives, which always kind of is a sort of confusing sort of term, like what do you mean advance directives? But advance directives, I think, really sort of encompasses documents that you put in place that in advance of when you actually need them, that are giving directions or directives of what you want to have happen in the event that you can't make decisions for yourself. That's, in my mind, encompasses a power of attorney. It encompasses a living will. It encompasses naming a healthcare representative or healthcare proxy. And then I think you could even say, it's a will, it's, how you want your estate to be distributed, but really it's really thinking in advance of what you want to have happen when you're not able to make decisions for yourself. So what I have to talk about today, but we can veer off in sort of any direction that you want. As I said, I am particularly knowledgeable about probate and probate process, probate administration, what the probate court does, and so I can answer questions on that. I also have background in estate planning, estate settlement. The estate planning is anything from people who just want a simple will to more complex planning for families that have children with special needs, families that have children that shouldn't inherit all their money outright, things of that nature, trusts. There is some tax planning that we do, although the exemption is so high that it's now $13.1 million, so very few people fall in the taxable estate category. I don't do a lot of Medicaid planning. I typically say I have done it, but I know enough to be dangerous. So, and I also know enough to answer some questions and refer you out to an attorney that really does know some and specialize in Medicaid planning. So if you think at some point you're going to require Title 19, there are some things you can do to spend down your assets so that you can preserve certain assets for yourself, for your children, and then qualify. In any event, I've done a little bit of that, so we can talk a little bit about that as well. I do have the materials today that starts off with what's the difference between a DNR and a living will. And this is because people constantly get confused about what those two documents are. And we've talked a little bit about that in this group, but I thought maybe we could touch on that. And then some examples of what exactly your living will says from the statutory standpoint, what your appointment of a healthcare representative would look like if you put that document in place. Because I always think, and I say to my clients, we can talk all about this, but until, for me personally, until I see like what's the document look like, then it's much easier to be imagining who you want to put in those places, what have you. Connecticut has sort of an all-in-one form. That's your living will, your designation of a healthcare representative, designation of conservator should you need one if you become incapacitated, organ donation designation, and that's the healthcare instruction document that you have. It's just a draft type form, but I thought it's just interesting to be able to see it. And then you know what we're talking about if you want to put one in place. If you go to a lawyer and say, I want to do a will, they should typically this should be something that they do for you. It is not complicated. Just a simple will is going to be okay. But typically when you're talking to a lawyer about putting your last wishes in place, getting your health care instructions in place, power of attorney in place, and then the other document that we have that we've also talked about, but I wanted you to see what it looked like, is the dispositions of remain document. Again, it's a draft. You can kind of see what it says and looks like, and we can talk a little bit about those documents too. But I just thought it would be interesting because we've been kind of bandying around this type of document and that type of document, but there's nothing, I don't think, better than just saying, okay, that's exactly what it is. So I wanted to know a little bit about, since we're a very small, intimate group, a little bit about what you folks wanted to talk about today so that I don't blather on, although I could, and bore you all. So why don't just I know we've all been together, but you do me a favor and just introduce yourselves and let me know a little bit about why you're here tonight and what you'd like to talk about. So I'm gonna start with you.
I'm Liz Andrew, and I am taking this whole series because I've been through this with my mom and dad, and I was very confused through a lot of it. And I think the process took a lot longer because it was my first time. A lot of the terms, like conservator, all of these things were like foreign language to me.
What did you go through with your mom and dad, if you don't mind me asking? Was it just estate settlement, or was it conservatorship, that kind of thing?
Well,
or both?
I was pretty much the executrix for both of them, which I thought was just an honor to be, and I would never wish that job on anybody. I mean, really, it's
It's the
awful.
booby prize.
Yeah.
Yeah.
I mean, I had to make all the medical decisions, the financial, there's 7 of us. And I was it. And I had to have conference calls with everybody every week. I didn't have to, but we did.
Yeah, that was wise.
Yeah. And,
Well, that's the power of communication.
Yeah.
and I had to be able to explain what I was talking about. And I found it really, really hard. And so I want to be able to, when I sit down with my children, not pull all this out of my backside from back then. I want to listen to you people speak and say, oh yeah, I remember that, and now it's clearer to me. Because it's daunting if you're walking into it.
Mm-hmm.
And it's,
It is, and I think lawyers, oftentimes when you're talking to them, they are so familiar with the terms and
Yeah.
they know what they're talking about, but they don't realize that these terms are very foreign to most lay people,
I didn't even know what the word probate meant when my husband died. What is probate?
Right.
I still can't explain it.
yeah, well, that's the other thing. It's like, well, now this has to go to probate.
Yeah, or this doesn't have to go to probate, and you're like, what?
Well, my father-in-law died 2 years ago, and we're still getting paperwork about probate. I'm like, how is this happening? Why is this taking so long? It should be cut and dry. Either he owed or he didn't owe, but I guess it's deeper than that.
We, we can talk a little bit about the probate process when you die, if that's what people want to talk about today. I can certainly, in terms of, probate court does a lot of different things. One of which is, I try to tell people, we're here to help you settle, your loved one's estate. We're not here to make it more difficult. We want to move, these things through and try to be respectful of the fact that at this particular time, people are grieving and they're sad and often they're confused and they don't understand. And so, where we're kind of sending out notices, you got to file this form and you got to do that. I try to tell my clerks sometimes you got to step back a little bit and understand that these people are going through a very difficult time. And now they're also going through probate, which is nobody's idea of a good time. It's like the dentist, only it lasts longer, right? Nobody wants to go to the dentist. I say to, nobody really wakes up in the morning and says, oh, gee, what I'd really like to do today is go to probate court. So understanding that, that people aren't here because they want to be. They're here because they have to be and at a very difficult time in their life. But we can talk a little bit, if that's what folks want to talk about the probate process. Because some of this, when I look at what I've given you, it's sort of, we've talked about it. Noreen had sort of asked me to talk about this, but what I'd really like to hear is what you'd like to talk about, and what Liz said she wants to talk a little bit about is, what is the probate process when you die? So I can talk about that. But
I guess
just give me your name, your first.
Sabina.
Sabina, okay, thanks.
I come to these sessions because I want to make, when I die, I want to make it as easy as possible for my daughter. I just have one child.
Okay.
And I just want to make sure that she's not left with a pile of stuff that I could have taken care of.
Okay. Okay. That sounds like you want to talk a little bit more on the how to settle an estate as easily as possible side.
Yeah, I've made a trust for
Okay.
her. And I looked at it the other day as a result of coming to these sessions, and what did I put these people in there for?
Well, that was one thing I was going to say. One of the things I see as the probate judge is that some people put these documents in place. They've been, very, very responsible. They've gone to the lawyer, they've done it all. And either they didn't do the next step, which is you have a trust in place. If you've got assets in your individual name, like a house, you've got to retitle that property in the name of yourself as trustee. That takes it outside of having to go through the probate process, and it would make it very easy for your daughter. So
The kind of thing I need to.
so a lot of lawyers, they just put the documents together, and I will tell my clients, this is what you need to do. You've got this trust. Now, if you want to get outside of probate and make it as easy as possible for your children to settle your estate or your spouse, what have you, this is what you have to do. This is the beneficiary designation you have to put on these accounts. This is how you have to title the real estate, what have you. And some people say, oh, okay, that's fine. I want you to do it. But I can't usually, I can do the deed, but I can't usually do the beneficiary designations, update bank accounts with transfer on death designations and things like that. The other thing I see, and this goes to what you were saying, I don't even know who these people are and why they're in my trust, is I see that people have put the documents in place, but they've never updated them, right? So let's say you've named a kid to be your healthcare proxy or your healthcare representative, and that child is now nowhere to be found or has a substance abuse issue, and that's really not the kid we want. But if that's what you said in your will 10 years ago, I had a horrible, horrible case with kids fighting, and they really didn't want their brother to be the executor. But he was the named executor, I think because he was the oldest, At one point, he may have been more pleasant than he was now in the present. But I mean, I have zero flexibility when the will says I want my eldest son to be the executor, unless that person is mentally incapacitated or declines to serve. If that person is standing there saying, yep, I'll take it, I have to appoint him. And so sometimes I see that I don't think Mom would really have wanted this person to be the executor if she had taken another look, or similarly making the decisions with regard to healthcare. So I see people actually put the documents in place and then they file them away, they never look at them again. Now, you have one daughter, so she's probably the point person, and what my favorite term is the object of your bounty. So, but there may be grandkids involved that you would prefer to have as, remembered as beneficiaries now than some other people that might have been.
I mean, I know them,
Right.
they're relatives of my son-in-law, but then I don't have them in there. I do need to update this.
Okay, so updating is important, right? What's your first name?
Sarah, with an H.
Sarah with an H. Okay.
I mean, I have this, all this DNR living will, daughters will follow it. They're always saying, oh, we're going to have a big funeral. I don't want a funeral, period. I have that all in black and white.
Well, some things they have to follow, but if they want to have a funeral, there's exactly. You'll haunt them from the beyond. Right, right. Well, I think one of the things that let's talk a little bit about is that disposition of remains document. This is a really simple document. You can make it as complicated as you want, but it's basically saying, let's say Sarah, being of sound mind, I want my remains to be cremated. And sometimes I'll add, if somebody has a specific preference, I want my ashes scattered. Some people want it in the river, or some people want, in a I say sort of an ocean setting, or some people want to be in the woods, in a mountain setting, or something like that, so that you don't run afoul of the rules that require that you're not to be, sprinkled, out in the sound, you're not to be sprinkled on somebody else's property, but you just want to sort of have it out there about what type of environment you'd like your ashes spread. Or some people bury their ashes, next to their spouse or something. So you have the ability to say this. And then I think what would help for you is if you really don't want a funeral and you want to give somebody control over your remains, that's the person that you think is going to respect those wishes and not have a funeral. That doesn't mean your kids can't have a memorial service or a party for you. Right. But if you don't want this sort of funeral, then you're going to appoint the person that you think, this first named agent here, will follow those wishes.
I did a whole sort of thing with Stephen King.
Okay. Interestingly, Stephen King told me he'd never heard of this document before. Yeah.
Because, I mean, I've got everything in papers about
You may have papers of what you want done, but you need this document, because if you don't have this document, and there's a statute, a law in Connecticut that gives priority to certain people to have custody of your remains and decide what they want to have done. So when you die, how many children do you have? Are you married? Okay, so your ex, just so, the good thing is, the ex-spouse never has any control over anything, all right? They, even if they're named in your will as the executor or as someone to inherit, there's a law that axes them out. They can't control anything. So you have 2 children, and so that gives those 2 children, they would have custody of your remains. Stephen King would contact them unless you had this document naming someone else. And the problem sometimes is they're at the same order, we call it the level of priority. You know, we get spouse, no spouse, 2 kids. If you don't have any kids, it goes down to brothers and sisters. And when you have people at the same level of priority, no one has any more power than the other. So they have to agree. And if they can't agree, then they come to probate court. And then that's where they duke it out in front of me. So I do have those types of situations where we have children at different levels, at the same level of priority, and they can't agree on what to do with mom or dad. So if your 2 children are saying, we're going to have a funeral and that's what we're going to want to do, I think you need to find someone that is going to respect your wishes and not do that, because Stephen King is going to contact your children, and if they say, too bad, we want to have a funeral for mom, he has to, because they have legal custody of your remains. I suppose you could. This is a legally binding document. I've never had somebody name a funeral director, and I've had people want to name me, and I because they're funny. They say, I say, well, you know, like a power of attorney or something like this, an agent, and they say, well, you're my attorney. Aren't you going to do it for me? I think, I don't really like to make those types of decisions. I mean, sometimes I'll step in the financial piece if people don't have anybody, but I really try to find somebody, like perhaps your sister or a sibling is going to step in and say to your kids, this is what Sarah wanted, and I have been designated to have custody and control and make those decisions. So right. She could have a backup. On all my documents, I recommend a backup because it really becomes problematic. People say, oh, no, you know, so-and-so is going to live longer than me, what have you, but life happens. And it also puts a lot of pressure on that named person if they're in the middle of a crisis in their life and they can't do it. They can decline to serve, and then the second named agent would come in and serve. But I would say, you know, either your kids, you get a sense that they're going to respect your wishes, but if you really think they aren't, this is the one and only legal document that'll make sure that what you want to have happen happens. What else would you want to talk about today? Anything else, Sarah?
Well, you know what you were talking before about probate. Way over my.
We'll talk a little bit about probate. It does get complicated because it's specific to each individual, but we'll talk a little bit about that. What I did want to mention, though, is that you said you have a DNR in place, you have a living will, what have you. I'm not sure you have a DNR in place. Do you really have a document that was done by your physician that says you don't want, you know, if you go into cardiac arrest, you don't want CPR? Do you have a bracelet or anything like that? Okay. So this is one thing that I did want to talk about is people get confused about between a living will that says if you're permanently unconscious or in a persistent vegetative state, you don't want, you know, CPR, artificial nutrition, artificial respiration, things like that. The DNR is and a lawyer can do that living will document. The do not resuscitate order, and this is why I put it up here, it's a special order, it says, written by a physician that states your wishes not to receive CPR if you have stopped breathing or if your heart has stopped. And I have some people that will say, you know, my mom had a DNR and the EMTs came in and they resuscitated her. And I said, I don't think your mom had a DNR. I think your mom had a living will, but that's different from a DNR. It's two different things. So if you, Sarah, really didn't want to be resuscitated, if your heart stopped or you stopped breathing, you have to discuss with your physician putting this DNR in place. And then the only thing that works is a bracelet. You have to have the bracelet on when the EMTs come. That's the only, it either has to be on your wrist or it has to be on your ankle.
There's a woman at the Y pool who has one. She just recently, she's 93 or 4.
Mm-hmm.
It's a purple, like, you know, like the bracelets.
Does it have like
the cancer
rhinestones and
band.
stuff on it?
What?
Rhinestones?
Oh, it's all bling.
No, I'm kidding.
No, but it is, she has it. So that
I'm just
she's
wondering if you
offering
can bling them out.
she's
You
so
can?
afraid somebody
Can, really?
is not going to see it.
wow.
Right.
She's like, I don't want to come back. If I go,
Right, if
I
you're
don't wanna come
93,
back.
you may be at that point. You may be at that point.
Well, how do you get this bracelet?
You have to talk to
The
your
doctor.
physician.
Oh, he'll get it
And
for
they
me.
give it to
Well,
me. She
he'll
said
write
she
up
got it
the
at drugstore.
DNR order, and then I think you order it. I think you can order it, I don't know. You sounds like you know.
Yeah, I do. My husband has his DNR,
Okay,
so I'm Sharon.
Sharon.
So, my husband's DNR, so when he went into hospice, they require you to be, you have to make this decision if you want to be. In 99%. So they put a bracelet on you, but the bracelet that hospice puts on you is like the kind you get when you are admitted to the hospital. It's just one of those plastic ones that snaps on. So if you're in hospice for quite a while, which my husband happens to be, it gets really hanky. That's the only word for it. It gets, yeah, it's really gross. Yeah,
Okay.
and if you cut it off, then you no longer have that wish.
Right, right,
But you have to have the paperwork also.
right.
So they explained to me that I have to have that document that the doctor signs as well as wearing the bracelet because some EMTs will not go by just the bracelet. They want to see
Oh,
the document.
wow.
Which is tricky because you carry the document. You carry it with you all the time.
Yeah.
Everywhere I go with him, I have my little folder. Like we have it on the refrigerator. Yeah, I have it taped inside one of the kitchen cabinets. It's in a plastic document holder and all that. Then I have the copy that I carry with us wherever we go.
Will they honor a copy, or do you have
They
to have
better.
like a notarized?
Well, they better.
Yeah.
if you're the spouse, you're in a much different sort of
Right. So
situation than maybe Greta would be,
yeah,
right? Yeah,
you have to be.
right.
He's always either with me or with somebody who's But what happened was I needed a new bracelet, but he was discharged from in February, March, because he's so So I asked for a new one, and they're like, oh, no. And that's the key. Well, yeah, Dr. Birchnell said, well, get it in hospice. Give him one because he's not our patient. It's tricky sometimes. It's very tricky. So I still have the order because it doesn't expire, but I don't have this. So Dr. Birchnell said, maybe you could find one somewhere. Amazon. You know, I did a little research. No, actually, DNR bracelets are supposed to be black. So I just ordered one from Amazon.
See, I'm glad you said that because I was going to say, my understanding is you can order them online. If you're in the hospital, they give it to you. But these are things that you can actually order online. And I would suspect that, I'm
It's that
surprised Dr.
document.
Birchnell couldn't,
It's that signed document that really is what carries the weight.
Yeah.
No, I mean, I can't.
no, I, What
carry
did
that,
I-
I carry his medication list with me everywhere we go. It's like ridiculous. It's like,
Oh,
Yeah,
oh, that's just, sounds like this has been going on for a long time.
but it's just, you know, and I will say, when he became a patient at Heart Healthcare, they gave us the living will documents for him to fill out. They didn't give us the DNR, they gave us the living will, they gave us the healthcare proxy designation forms to fill out. I mean, they were very thorough.
This is hospice?
No, it was Hartford Healthcare.
Okay.
They became a Hartford Healthcare hospital. Oh, well, that's who he was with, but when he first became a patient at Hartford Healthcare, Chase Movement Center, he has Parkinson's and dementia. So he has Lewy body, Parkinson's severe. So when he started with them, they gave us so we had all that done. And then when we went into hospice, that's when they gave us the I have to say they were very thorough. So we had to sit down and I had to sit down and do all that paperwork and it was good that we got it.
Yeah, yeah, yeah. I've had situations where, clients have had living wills done, before while being in the hospital or going into surgery, that kind of thing. And I try to tell them, it's better to get it done before you're in that situation because, you're going in for surgery and they're saying, so if you die, and that happened to me, I said, well, I'm not planning on dying today. I'm planning on, and they just look at you like, "Mm." But I obviously I had my documents in place anyway, but
We had done ours 23 years. So it gave us the opportunity to update everything.
right.
So we just updated his everything. So if something happens to him, he's taken. But within that, I got updated within that. So I've spent like the last doing all this.
Yeah.
There is so
Yeah.
much. And
Yeah.
changing, like you said, changing the beneficiary, all the assets to the when since the first time we did our will, the boys were young. Adults married and about to be married. Making them executive,
Right.
all that stuff. So you do need to update it.
Like really just
Yeah.
at least look at it and say, okay, do I want to change something?
Yeah. Yeah, they can change rather quickly. Yeah.
And
Yeah.
that's not the first
No. No, especially if there's something dramatic. I mean, you're dealing with a lot of other things. If it's the death of a child and that child was the named executor, in your documents in the fiduciary, you're really grieving in that situation. Same thing with the passing of a spouse. A lot of people are really grieving and they don't get back in to update the documents, which is why, for me, it's really important to have a backup. Because I have spouses that, they lose their spouse, we do the planning, I think, come on back in, we've got to update all your documents, and they don't want to. And I say, well, you're probably okay because we've got backups in all your documents, but, we should update them. We should update them.
You may want to change.
This is the time to review.
I
Yeah.
dealt with my dad. What DNR, all of that. So it made me realize what it helped me with dealing with this, knowing that if you have it in place, what you're going to need, it just makes it takes that emotion out of it.
Right.
So it was,
At a very
no,
emotional time,
exactly. It just makes me to worry about it. Just have it there. It's there. Dad died, I made my mother. And I don't, I had to go to probate for my dad, but my mother was everything passed. But I still
So
gotta
we can talk
file.
about that.
Yeah, I
We
still
can
gotta
talk about
file
that. Even if you completely, quote unquote, avoid the probate estate process, you still have to file an estate tax return with the probate court. It's called, for most people with a probate court, it's a non-taxable estate tax return, basically saying to the probate court, this person passed away, these are the assets that they owned, and you tally up all the value of the assets at the date of death, and if they don't meet the threshold of $13.1 million today, the probate court will give you a certificate saying that you didn't owe any tax. They'll also give you a small bill based on the gross estate. And it's not a big bill, to be honest. It's 0.25%. So, it's not going to kill you, but people don't, I appreciate that people don't want to pay, but it functions like a tax to fund the probate system, which does a lot of other things besides settling estates. We do children's matters, we do guardianships for adults with intellectual disabilities. The conservatorships are typically the elderly who have no one to make decisions for them. We have to appoint attorneys for them and professional conservators. There's a whole world of people out there that you'd be surprised have very, very little resources in terms of funds and people that they can lean on, and that's when the probate court comes in to help. So some of these fees that you pay, you think, well, the probate court didn't do anything to settle my mother's estate. No, we didn't, but it basically functions like a tax to help fund some of the other work that the probate court does. So even if everything passes what we call outside of probate, you're going to have to do what's called a tax purposes only estate, which is just filing that estate tax return and getting a release of lien and paying the fee. And that's pretty much it. You still have to gather the assets and get the valuation of them, bank statements, brokerage statements. You can value the house if there's real estate. It's really important if there's real estate to get that release of lien and get that filed on the land records, because let's say your parents own property jointly with rights of survivorship, or you and your husband own property jointly with rights of survivorship. You need to show on the land records that one of the spouses has passed and that it has now passed to the surviving spouse. And that's done by filing the release of lien, showing the decedent owed no tax, owned property, and it's passed to the surviving tenant. So that's kind of the minimal that you have to do, and that's how you make it really easy for your kids. So to do that, let's say you've got an estate that has, let's say we have an estate, I'm just thinking whether we should do an individual or married couple. Let's just do an individual, right? Let's take, so an estate is, it basically, while you're alive, all your assets are your own, right? Your house, your bank accounts, your brokerage accounts, your IRA, your life insurance, you direct what's done with them. You can update things and change things. Once you pass, we call an estate sort of that universe of assets that you had. What was the person's estate? What assets did they have that need to be managed now that they're dead? Now there's an executor. We all know an executor gets appointed. Whoever is named in the will get appointed. But sometimes you don't need to have an executor appointed. If you don't admit the will to probate, because there are no assets to be administered in the probate context, you don't need to have an executor appointed. The way you can avoid probate is by having all of the assets pass either by beneficiary designation. So let's say you have life insurance. You would name a beneficiary and make sure there's a beneficiary named. You'd be surprised how often people don't have beneficiaries on life insurance. And if you don't have a beneficiary, it's going to get paid to the estate, and it's going to go through probate. We'll talk about what happens when things go through probate. But if you have a beneficiary, it's just going to go directly to the beneficiary. Same thing with a retirement account. If you have a retirement account and you have beneficiaries named, probate court doesn't get involved. The financial institution that's custodian of those assets has basically your beneficiary designation. Says, okay, this is going to Sarah's 2 kids, and just goes out, and the probate court doesn't get involved in that at all. The will doesn't control it, nothing. So the beneficiary designation for life insurance and IRAs are key. But let's say you have a brokerage account, and if you're lucky, you've got $1 million in that brokerage account, and it's just Sarah's brokerage account. Yes, yay. And let's say you die, and now the brokerage account says, Sarah's dead, what do we do with it? Well, if you have what's called a transfer on death designation on that brokerage account that says, I want you to give 50% to one child and 50% to my other child, that transfer on death designation is like a beneficiary designation. For some reason, we have to call it a transfer on death designation. I don't know why. It's different for brokerage accounts and bank accounts. But you can put a transfer on death designation on a brokerage account or a bank account that's not a retirement account, and the financial institution or the bank will just give that money directly to those individuals, and it doesn't go through probate.
I have a question.
Yes.
If your TOD is both children, who just, does it go 50-50? That's what the bank, the institution will do, 50
Yeah.
to you and 50.
Right.
Okay.
Yeah.
So there's no fighting over, Joe got more than me.
No,
Okay.
no. I mean, you could say, I want 75% to go to Joe and
Yeah,
25% to go, but typically it's,
Okay.
to my children, a
I
lot of
didn't know
times.
if you had to designate, the percentage.
I would, on the form, I would say 50-50, but I
Yeah,
would
yeah.
presume if you don't say 50-50, I mean, that's what they're gonna have
Yeah,
to do.
okay.
There's really no other way they could do it. But you could upend it with whatever you want.
Yeah.
The other asset that people typically have is, a house. And the house could be owned jointly if you have a spouse, you own it jointly with rights of survivorship. And if you pass, it'll go to the surviving owner. No probate will be involved. Except, and we talked about this, except you have to file that tax return showing the value of all these assets. But the probate court isn't going to get involved with who gets what. So even if your will says, I really want my niece to get everything, because I really love her and I don't like my kids, and this is what people will do, they're like, well, but if your beneficiary is your kids, your niece isn't getting anything. And so we really have to talk about the fact that the will only controls what goes through probate. It doesn't control assets that already have a beneficiary designation or if they're owned jointly. I mean, I've had problems when parents put kids on savings accounts. So there's one kid that's helping you pay bills, is there day in, day out, and you take them to the bank and you've got a checking account and a savings account. You say, I want you to help me manage my money. I'm going to put you, Joe, on the checking and the savings account. Well, if you have a checking account and you, Liz, and your child, Joe, are both on as signers and owners of that account, when you die, that money legally goes to Joe. Joe's a nice guy, he might split it with his sibling.
Yeah.
But from a legal perspective, that asset passes outside of probate because it's jointly owned, and it's just going to go to whoever the co-owner is. And this has caused, I can tell you, no end of trouble among children. Whether did dad really want this child to get an extra $500,000 because they say, but the will says we split everything equally. But it doesn't matter. It doesn't matter. Unless you could find, and sometimes I've had cases when I'm the lawyer, where I represent the kids that were left out of that $500,000. Sometimes I've got the other one, right? Where I've got the kid that says, nope, dad wanted me to have it. But unless you can prove that there was some undue influence or that dad or mom lacked the capacity to know what they were doing when they put the kid on the account, and there's oftentimes you can prove that, oftentimes mom's not 100% with it, has dementia, and the kid takes mom to the bank and says, Mom, I got to help you pay all these bills, just put me on the account. The bank, the bank manager comes in and says, yep, we're just going to add Joe to the account and everything's going to be fine. And Mom, just sign here. We can get doctors, medical records and things like that show mom had dementia, didn't know what she was doing, and really Joe was not supposed to get all that money. So you kind of have to be careful. It does make a lot of sense to put, your child who's helping you on a savings account. I call it sort of your operating account, right? So you can pay day-to-day bills and things like that. But if you've got a large savings account, which is sort of money that you want to go to the objects of your bounty, don't put name one kid as the co-owner of that account, because that passes outside of probate and goes directly to that kid. And the wishes in your will are not going to be respected. So that's how you get out of probate. That's how you can make it very easy for your kids or your daughter. Make sure that she's the named beneficiary on everything. Just double check everything. And that's what I do with clients. I say, come in, let's double check. This is the time. This is the planning that we're doing. I make sure they double check everything. Make sure that she's on as transfer on death designee on your bank accounts. The other thing that we didn't talk about is having a trust in place, what we call a revocable living trust, or a living trust, which means that you've put it in place while you're alive. You can put assets in it while you're alive. You can manage it while you're alive. It doesn't keep it from being an asset available to you if you want Medicaid. It doesn't keep it from being an asset that is going to be subject to sort of this estate tax return where you have to report all your assets of probate, because it's still yours. All the income tax is reported to you while you're alive. But if you put your assets in the revocable living trust while you're alive, so let's say Sabina has a brokerage account, and it's got $1 million in it. She could either have this transfer on death designation to her daughter, or she could name the brokerage account as, Sabina, trustee of the Sabina Revocable Trust, and that brokerage account is going to, when she dies, is going to be distributed pursuant to the terms of this trust. I have just had a client die. He did have several $1 million, which he left to his great-grandchildren. And you can imagine that his kids and his grandchildren weren't going to be super thrilled about this. So guess who he made the trustee? Me. So what happens when he dies, he was the trustee during his lifetime. He lived to the ripe old age of 96 and was pretty with it for most of the time, although one of the most stubborn people I've ever met in my life, but lovely. So I'm the trustee of this trust. When he died, I needed to get a tax ID number for the assets in the trust, and I needed to move the assets in the trust into a new account with myself as trustee. And I have to tell you, a lot of people get upset with me. They say, this was supposed to be seamless. I wasn't supposed to have to do anything. But this is all for tax reporting purposes. Everything was reported to the grantor when he was alive under his Social Security number. Everything, once he's dead, needs to be reported to a new tax number with myself as trustee. And then from there, I can distribute it out to the great-grandchildren, and there are trusts that are set up for them. So there are a couple of steps that have to be taken once you die, even if you have a revocable living trust, unless it's just your daughter. If your daughter, you die, everything in the trust goes to your daughter, she would become the successor trustee, and then the assets would be distributed to her. So easier, but there's still a little bit of a process. But a trust can be a really great tool to make sure that, for certain assets that you want to have pass out outside of probate. There's real estate, too, that you can put in the trust, because real estate is difficult to have pass outside of probate, especially if you don't jointly own it. You could have real estate, and so let's see, Sabina has a really nice house. She wants it just to go to her daughter. She could do a deed retaining a life estate and deed it over to her daughter now, where she retains life use of the house, but her daughter is the owner. And then it doesn't have to go through probate. It just gets reported on that estate tax return that we talked about, and there'll be a release of lien. And the daughter actually owns the house, but subject to. No. 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 It's just a way that, now this is also something that to talk to your attorney about, because although it works pretty well, because you've just basically gifted the house to your daughter, but because you retain life use, it still gets the step, I know this is a whole nother issue, but it still gets step up in basis and things of that nature, which are sometimes a concern. But your daughter owning the house, let's say she gets into a car accident and hits someone, and now the house is subject to a judgment. It's an asset that she owns. They can't do anything while you're alive, right? The asset is, they can't take away your life use, but it could be problematic if you give your property away to your child. And because a lot of people say, well, I'm just going to give the house to the kids. I'm like, well, you're not going to do that unless you retain life use, because if something happened to the kids, and we've seen situations where parents have sold their house and said, I'm going to go move in with my kids, and then they don't get along with their in-laws, and then they're booted out, and they, all sorts of things happen. So real estate is really sort of it's something that you really need to think through how you're going to handle that. But the trust is a great option, because it will get it outside of probate and then down to whomever you want it to go to. So.
Is there a tax consequence, though, if you do the living life estate?
You actually still get the, in terms of the income tax write-offs?
No, the property.
The property taxes? I don't know.
Because
Are
if
you
don't
aware of
own
that?
it, you don't have the tax write-off then.
With your life use?
It's
I'll look
ownership.
into that. I'll look into that.
The ownership.
Well, you still have ownership in it. You have a life, well, you're right.
Entitled.
Let me ask about the property taxes on that. This is something that is done all the time.
Right.
All the time. But I don't know who gets to take the property tax deduction on the income tax return. I'll ask. I'll report back next month. Yes, ma'am. Okay.
Good. She wants to know if you took over all the files from retired.
Did I take over all of them? Yes. Anything that was still active. Yep. So, hi, Maura. Anything that was still active when Judge Keppel, any file that was still active when Judge Keppel retired, that was in the court, then I am now the presiding judge over those files. Yeah. And I had to go through the files and make sure I had no conflict of interest. So there would be some files that Judge Keppel could handle in that court while he was judge, but they were actually either, so for example, my father's files, and I'm in practice with my father, who's Ted Ladwig, I had to recuse myself and have another judge handle all of those files. But I would say that was few and far between. So for the most part, yes, I've taken over all those files. Yeah. I'm just writing down my to-do list. So I probably have made things about as clear as mud today.
I still want to know the definition of the word probate.
Probate.
What is the definition of that word?
What is the definition of probate?
It must be in the dictionary. A Latin word?
I don't know. Can somebody Google probate?
I was just going to
Because I should know, of all people, I should know, what is the definition of probate?
Oh, I thought it was our task. What is probate?
Okay. Sharon, while we're doing that, was there something, you've been very insightful and knowledgeable today, but was there something you particularly wanted to talk about? I think we stop around 6:30, don't we?
We do.
Okay, time flies when you're having fun talking about death and
This has
dying,
really been
right?
great though, hasn't it? I mean, I just love this.
Yeah,
Complicated issue.
yeah. Was there anything in particular you wanted to talk about? Sounds like it's something you've spent a lot of time, organizing, thinking about, thinking through. And honestly, from everything you've said to me, it sounds like you've done a really good job getting things together
Don't have to
in a,
take my in-laws
in a very difficult, couple of difficult situations. Yeah, yeah.
and also different stages.
I'm impressed.
I have to say, with my in-laws, it was a very smooth. They have 4 children, 4 in-laws, so and there were no arguments, nothing. My sister-in-law was the executrix. It was very smooth, like one of the smoothest processes ever.
I would say, some estates are very easy to settle. And I would just say, if there's real estate involved, it can be difficult. You've got houses to clean out, kids have to decide on, separating out assets. Then you have to put the property on the market, sell the property, that can take months. So we were talking about sort of how long, why does it take so long? Typically, the typical estate, when we issue what we call fiduciary papers, we admit the will, or we open an intestate estate, which somebody didn't have a will, doesn't matter, we give you 12 months to settle the estate. You have 2 months to file an inventory, which is a listing of all the assets that the decedent has. You then have 5 months to file what's called a return of claims, and that's all the debts that the decedent had. You have 6 months from the date of death to file this estate tax return that we're talking about. Even if you don't have a taxable estate, you file it with the probate court. And that's really just so you've got to round up all the assets, get all the valuations done. And sometimes it's really easy. It's a bank account, it's a brokerage account, you put them down. Unless you have very valuable collections of artwork, coins, or things like that, we can get sort of an estimate. Most courts will accept it, just sort of an estimate of a couple $1,000s for household furniture and furnishings and things like that. So the 6-month period will come rather quickly. People are sort of surprised, oh my gosh, it's already 6 months. If you've got an executor in place that's really on the ball, that's great, but sometimes you don't, and the court will sort of send out reminder notices, inventory is due, the list of claims is due, the tax return is overdue, that kind of thing. And then after the tax return is filed, you should be in a pretty good position to file an accounting, which is basically and a proposal for distribution, which should follow the terms of the will or intestacy. And that basically says, this is the assets that the decedent had when he or she died. These are the assets that came in after. This can be refunds, things like that. You can sometimes get a refund on health insurance, that kind of thing, that then you'll report. These are the expenses that we had. This is what we paid the attorney. This is what we paid the probate court. This is what we paid the creditors. And then, the assets plus the income less the expenses leaves X, $1 million. And I have 2 kids that are the beneficiaries under the will, and they're each going to get $500,000. The probate court will then approve that, have a hearing if somebody requests it. If not, it can go fairly smoothly and go through probate. But I think at a minimum, you're looking at 6 months from date of death, 6-7 months from date of death to settle the estate. And it can take, I have estates that years, because people are fighting, because there's real estate that doesn't divide that easily, that kind of stuff. So, okay.
So the definition of probate is exactly just what you do. Probate is a formal legal process that gives recognition to will and appoints the executor or personal representative who will administer the estate and distribute assets to the
So that's probate. And interestingly, the probate court does a lot more than just that. But that's what I think people think about, and I think that I was hearing that that's what people wanted to talk about today. You know, what is this probate process? And I hear about avoiding probate process, and how can I do that? So
So it doesn't matter your financial, whether you have millions or thousands.
no,
If you have thousands, it could take just as long as somebody who has millions,
it could. It doesn't typically,
depending on
though.
who's involved.
Right. Yes, it could. Yes.
Okay.
You could. You could.
I mean, you could actually give all your money away, right? You could give it to your children.
There are, in Connecticut and at the federal level, there are gift tax returns that need to be filed if you give over the exemption amount, which is, actually it's the annual exclusion amount, which is $17,000 a year. So if you give someone real estate, say, and it's valued at $500,000, you can give it away, but you have to file a gift tax return. And then on the estate tax return, you have to report all of the gifts that you made, because those are part of your taxable estate. Yeah.
No, I'm not saying that she's doing it, I'm just saying the system.
No, yeah.
Yeah.
Oh, yeah.
Well, it used to be, before the exemption was $13.1 million. The exemption went from, in about 2000, $1 million to 2023 to $13.1 million. Most people sort of in our neck of the woods, you know, with real estate, even if you didn't have a lot sort of liquidity and cash, people here in, you know, in our town and surrounding towns have real estate, and they could very quickly get up to that $1 million exemption. But at $13.1 million, the estate tax is really sort of it's insignificant for most people. But people hate the estate tax. Yeah.
Okay.
All right. Thank you. And I'll be here. You know, I you know me. I love coming and talking about death and dying. So I'll be around if you have other questions.
The next one is November.
I have a legal business card, but you don't want to hire me necessarily, because I can't. Then I couldn't be the judge in probate if I helped you. So.
I just want to update my trust.
Okay. Okay.
I don't know whether to go back to the person who did it for me, but this is like 3 years ago.
Okay. Okay. Well, I'll give you my card, and maybe we could chat, and I could give you some names of people that would work for that. Okay. Yeah.
So the next date is November 9th, and it is with Dr. Ken Donovan, who is a college from Lawrence. Fun fact, he's also
Oh,
Oh,
wonderful.
he's also
Said
a
fun fact, he's
husband.
also my
The next speaker.